and definition of jurisprudence. The study of jurisprudence started with the Romans. Okay, it is derived from Latin word jurisprudentia, which means either knowledge of law or skill of law. The word juris means law, and prudentia means knowledge. Both combine knowledge of the law, or the science, or the skill of law. Okay, thus jurisprudence signifies knowledge or science of law and its application. In this sense, jurisprudence covers the whole body of legal principles in the world. Okay, now let's see the meaning, real meaning. In its widest sense, mean knowledge of the law, as we have seen before, but in its limited sense, evolution and expansion, explanation of general principles upon which actual rules of law are based. It is mainly concerned with the rules of external conduct which people are compelled to obey. Therefore, sometimes it is said that jurisprudence is that jurisprudence is that science which gives us knowledge about law, but the term law we always use in its abstract sense. That means not in the sense of concrete statutes, but in the sense of principles underlying law. That means we take care about the principles underlying the law, not the whatever it is written in the law. We don't care that. We care about what are the principles underlying the law. Thus, for example, there are various branches of law existing in the modern legal system, such as contract, crime, trust, properties, companies, labors, etc. In jurisprudence, we have to study the basic principles of each of these branches, and we are not concerned with the detailed rules of these laws. We definitely study these laws in detail when we study those branches of law separately. Jurisprudence examines the general principles of law, therefore, jurisprudence may be considered to be the study and systematic arrangements of the general principles of law. This is the basic definition of jurisprudence, which you can write in the examination. We have seen the meaning. Let's see the definition. It's just like that. It's very difficult to define term jurisprudence. However, several attempts were made in this context to define the term. Some of the definitions given by eminent persons are here it is. Austin. Austin was the first jurist to make jurisprudence as a science. He defines jurisprudence as philosophy of positive law. He opines that appropriate subject to jurisprudence is a positive law as it is existing law. In other words, jurisprudence is not a moral philosophy, but it is a scientific and systematic study of the existing, actual, and positive law, which as distinguished from natural, ideal, or moral law. Austin divides jurisprudence into two classes, that is, general jurisprudence and particular jurisprudence. According to him, general jurisprudence is the philosophy of positive law. On the other hand, particular jurisprudence is the science of any such system of positive law as now actually obtains or once actually obtained in a specifically determined nation or specifically determined nations. So basic difference is general jurisprudence talks about the philosophy of positive law in overall, but particular jurisprudence is with respect to a particular nation or specifically determined nations. So that is the difference. What is the criticism? uh, Austin definitely criticized by Salman and Holland. They say that, uh, let's see what they say. Holland, he says jurisprudence as it is the formal science of positive law. According to him, jurisprudence should only concern itself with the basic principles of concepts underlying the any natural system of law. Criticism. Many eminent jurists have criticized the definition of Holland that jurisprudence is the formal science of positive law. It is not free from defects. The question arises, what is formal science? Holland himself explained that by the term formal, he means that jurisprudence concerns itself with human relations which are governed by the rules of law rather than material rules themselves. For the latter are the subject of legal exposition, material rules, criticism, or compilation rather than jurisprudence. So that is the difference. He talks formal science means it concerns only with human relations which are governed by the rules of law rather than material rules themselves. So, underlying principles he talks about. What does Salman says? Salman says it is the science of the first principle of civil law. According to him, it can be defined in two senses. Generic sense jurisprudence can be defined as science of law, and specific sense jurisprudence can be defined as science of the first principle of civil law. First, it is science of civil law, and second, it is science of the first principle of civil law. Civil law consists of rules applied by courts in administration of justice. Salman agrees with both Austin and Holland only to the extent that jurisprudence is a science, a systematic study of basic principles of legal system. So that is all about Salman, Holland, and Austin.